Good afternoon, everyone. Anthony Thorpe again. Still here discussing the corruption in the Supreme Court of Jamaica and how it's affecting not only me and my partners, but the entire country, all the Jamaicans living in Jamaica, and the economic damage it's being done when we allow corruption. And I'll always remind viewers that it's only a small group of people that are doing this damage to the country. And in this particular case, that has caused more than $4 trillion projected damage to the Jamaican economy over a 15-year period or 16-year period, is what I'm fighting to expose, because in so doing, it will help you who aren't exposed directly to the damage that's being done to realize that it does affect you. Because if it does affect the per capita income of persons in the country and foreign and trade disparities resulting from their action, it does affect you. You damage the economy, you damage the country's potential for earnings, then it's damaging the country, it's damaging you. And so again, I'd like to remind you to look at the videos that we're putting out. People typically don't have time for lengthy videos, but these have to be lengthy for the simple fact that it involves a lot of intricate details about what's going on. And if I'm to impart to you, the viewer, what's happening here, then I have to be factual, and factuality, or being factual, brings documents, and documents bring discussions bring presentations, which are often lengthy. So I'm going to try to keep this short. So again, good afternoon. It's February 2nd, 16th of February 2023, and another insert on the corruption. Yesterday I presented to you and discussed at length evidence that Justice Kirk Anderson did some really unscrupulous things in terms of his adjudication of matters that resulted in illegalities, simply put. And he forms part of a greater conspiracy that's undermining this country, and in fact totally destroying our trust in the Supreme Court. And again, it's only a few. Well, from my experience, I think the numbers there are more than I know, because not all the judges I have come in front of, but certainly the ones I've come in front of, the data and the statistics are crazy. And even though the court's rule were now designed on its new operational structure to ensure that one judge doesn't get to sit on matters consistently, if you notice in this matter, which involves the largest fraud and scamming of money and property from anybody that has happened. In fact, it's more than Bernie Madoff. Bernie Madoff was, I think, 300 and something billion. We're talking trillions of dollars, US dollars. So if you can fathom that, then sit down and write some numbers, and then divide those numbers by the population of Jamaica, and you'll see how much damage has been done to each of our citizens. So it's not just about me. Yeah, we're going to get paid, that's for sure, because we're not playing around, and we're going to ensure that our property is protected, because it's protected under the Constitution, it's protected under the law, and it's protected under the judgments we received. So we're confident we are going to get it done, and we're going to get it done by exposing these criminals who keep playing around in the courthouse and damaging people and upsetting our lives. Because if you commit a crime, you're a criminal. And if the law reform fraudulent transaction act said if you carry out deceptive actions, whether written, stated, or implied, you're committing a crime, and you should be charged and put into prison. No longer talking about resigning, because you're too cruel. Those of you who've participated in this fraud and this scam must go to prison, so you become an example for persons who are looking on. Said, criminals don't get unpunished. That they're punished for what they do, because you harm people, you harm people's lives, and it's not okay. It's not okay. You don't know better than somebody who takes a gun and go in and rob people and take their property and then hurt them. You destroy lives. You hurt my health of my partners. I've lost partners who probably were so depressed they couldn't wait any longer. And we have to deal with it. So I'm here again today to put out further evidence and to say to the Integrity Commission, which I was largely addressing yesterday, and I'm also now addressing the JCF. Don't fall for the nonsense. Please stand up and do your jobs. I'll say to the viewers that I did get an email from the JCF, the fraud squad, this morning. Didn't say much. It just acknowledged that they received a letter I had sent some time ago to them, which means somebody over there is now paying attention. So I want to again thank the viewers for sending out and those likes and submissions. So the public and law enforcement can see that people are concerned. And when you come back and read and view those videos and share them, that serves even greater, the greater purpose of letting law enforcement know that Jamaicans aren't going to be complicit any longer and sit down and just accept the fraud and the criminality which goes on and which law enforcement tends to ignore because it involves people who we perceive have power or they're in the upper echelons of society. It doesn't matter. You are the party, the law enforcement agencies that are there to serve and to protect Jamaicans. And if one of us go afoul of the law, then you're supposed to execute your power that's been granted under the Constitution, regardless of who it is. So again, I'm here to say to law enforcement, to the Integrity Commission, and to the JCF, thank you for responding, but we need to see action now. And you have all the evidence in front of it because we sent it to you before. But just in case it got lost in the X-Files, I'm telling you where you can find it. It's in the court's records because we filed everything we're stating to you and to the general public. It's filed in the courts, the Supreme Court, and to a lesser extent in the appeals court, because we've had to go over to the appeals court with certain matters as well. It's with the FBI. It's with the Integrity Commission, which we served to you. It's with the JCF. Obviously, we sent it to you. But more, it's in the Bankruptcy Court of the Southern District of the United States. All right, so in Florida. So you could go into the Bankruptcy Court and find those documents. And the reason we made sure we filed everything, including ones that the trustee tried to block or the corrupt judge tried to block, because it's in the records. They can't go in there. Well, let me not say can't. But it's more difficult for them to hide records there than here. So I've given the number for the bankruptcy proceeding, the file number, before, and I'll try to find it and give it again. But it's there. It's also with the Fort DCA Appeals Court. It's also with the Circuit Court of Florida, of the state of Florida, 15th Judicial Circuit in West Palm Beach. I filed it there as well. So, and filed it with several, the Controller of Currency, U.S. attorneys. I filed it with even the stock exchange on Wall Street, New York Stock Exchange. And it's in the public domain. It's in the air. It's in the clouds. All right. So this perception that's floating about there that if they take me out, then this ends. No, it doesn't. I have several partners and people with interest, which is also in the court's record. So God forbid anything does happen to me, natural or unnatural, then the police, you can go in, it doesn't die with me, in short, which is some of the games they play. You figure if you have a case in court and you die, the case dies. No, it doesn't. The successors in the interest of the developments we're doing and for the damages, which is also property, and the property that they've been trying to steal through various methodologies and strategies, there are other people involved. So the idea that if they take me out, it ends here, no, it doesn't. So I'm saying to law enforcement, there are no excuses, and don't fall for the tricks. When you're going to court and lawyers play this game or trying to trick the system or trick the judge, it's a crime under the Fraud Act, which I quoted earlier, the Law Reform Fraudulent Transaction Act. Games and trickery is not legal strategy, it's fraud. So when you're going to the court with documents stating one thing when it's not. It's fraud. When you go into court and you make statements that you know are fraudulent, lies in short, it's fraud under the Act. And it's not legal strategy. I know some judges might think, oh, when they come in and they pull those stunts and they rule against people, oh, they made some good moves. No, you'll also be participating in fraud and corruption, because that's why the rules of the court states clearly that no judge can embrace or make any beneficial order to somebody that comes into court on the basis of fraud. That's stated there. In most jurisdictions, I know anybody coming into court misinformation, they know it's fraud. And in the U.S., in the U.S. courts, it's called fraud on the court. And as I have said in the past, the JCF fraud squad in Montego Bay had said to me that they need a court order to investigate the fraud in the court. And as I said then and will say now, that Justice Sykes, who was not the Chief Justice then, said he wasn't going to grant it. The orders are in the court. So again, you can check the records. I also filed documents in the courts, as well as with the then Minister of Justice, Mr. Mark Golding, and with the Justice McCullough, stating where Justice Sykes stated he wasn't going to grant the order because a lot of people could get into trouble. I filed a complaint immediately after that. So these are all factual things that could be checked and verified. Nothing is being said. And what I would love to see, and the Jamaican people needs to see, is that the JCF goes in without prejudice or favor and asks the questions. Why did you make this rule in light of the fact that the court and the rules of the court says you shouldn't have? And that's applying to all the judges that I have named in the process. Kirk Anderson, B. Morrison, Justice B. Morrison, Justice lady, I'll come up with her name later. But these are questions you need to ask these specific judges in this matter. And when you check the records of the matter, you see there are several orders that the judges gave orders in contempt of the court itself. And the rule again, and in fact in one case, this case, it went to the appeals court. So when it went back down to the law courts, back to the Supreme Court, no judge there had any kind of authority or jurisdiction to make any order contradicting the rules of the court. And in one instance, I'll say this: Certificate of Results of Appeal, Rule 2.181. At the conclusion of each appeal, the registry must prepare a certificate of the results of the appeal in Form A4 and the results of the appeal in Form A4, and file a copy at the office of the court below, serve a copy on each party of the appeal, and C, the judgment of the Court of Appeal shall be enforced by the court below. In order, it's not saying maybe, it's optional. The judge can decide he's not going to do it or not. It says here in C, 2.181C, the appeals court sent over the documents as in A. They filed the document and served it on each party. And C says, the judgment of the Court of Appeal shall be enforced by the court below. The question for the JCF is, why am I still in court? Why are my partners still in court? Why are we being denied the judgment we got from the Court of Appeal? When the Court of Appeals rules said the judgment below the judgment of the Court of Appeal must be enforced. So when the Court of Appeal ruled that Capital One had absolutely no standing or claim or anything in that matter, nobody owed them anything or matter, they should even be in Jamaica, period, and that it must be dismissed and sent it back to the Supreme Court. Why is it that Justice V. Justice V. Harris gave them an injunction? Was it trickery? Because if the judge was tricked and fooled by Capital One and its lawyers, John Graham or Trevor Hollin, then they've broken the law. Not only the rules of the court, but they broke the law because they tricked the judge. And so that would fall under the Law Reform Fraudulent Transaction Act. And even if that law didn't exist, it would still be fraud. So if the judge was tricked, then that's fraud. If the judge wasn't tricked, then the JCF must ask the judge, kindly explain to us, why is it that you made orders giving an injunction against people's property? And giving orders against people's property is against the law as well. It's against the Constitution. The Constitution states clearly that nobody can, under the color of law, take people's property or deny them the right of access to their property. So I want the JCF to ask these pertinent questions in any investigation, as well as the Integrity Commission. These are questions that you must ask, because it's part of the process of determining how much time these people must get, how many counts you're going to charge them with. Because I'm way past the idea that we're merely going to check if these things were done. Here's the evidence that we're providing. We're telling where it is. And the good thing about this, it's already in the court, and everything that they've said and done is certified in the court and authenticated, and you just need to print it from the court's record. So this shouldn't be a long process of convicting these people. You don't have to do any virgin investigations. All the documents are there. So here I just read the rule where the Court of Appeals orders must be enforced by the court below. Hence, when it came in front of Justice V. Harris and she extended an injunction, we know why was that done. And why after Justice V. Harris extended that injunction, it went to Justice McCullough. Not McCullough, sorry. What's her name? Justice... She's in Cayman now or something like that. That justice, anyway. She also extended the injunction and refused to dismiss the matter, even if it was there. When it came up in front of Evan Brown, Justice Evan Brown, why did he extend the injunction and refuse to dismiss the matter? When it came in front of Justice Sykes, why did he refuse to order an investigation on the fraud? A. B. Refused to dismiss the matter, which was also in front of him to be dismissed. Gave orders for me to go find attorneys from New York and from Florida to determine if Capital One can file matters in the claim that was in front of him, which the appeals court had already ruled that they don't have standing. But no, I was given the task to go do that, because why? Justice Sykes was trying to create what's the term? He was going to create a situation so he could grant an unless order. You know what unless order is? That if you didn't perform what the judge said, they can't strike your matter or do anything or give orders otherwise. Because if the guy wasn't going to go get those people, which I did, and when I did get them and sent an attorney to file to represent me in court, Justice Sykes wanted to sanction me for not being in court, because he wanted me to make the presentation as opposed to the attorney that came. When Capital One was never in front of anybody except Justice Beswick, Justice Beckford when this matter started. So again, why the prejudicial treatment? What's different between me and the other parties? Deception. Deceptive action. So he's going to create a situation so he could grant an unless order. And if I didn't protest vehemently about, now I'm not going to settle for that garbage, and file a complaint to Mrs. McCullough, Justice McCullough, and to the Minister of Justice, and so he could recuse himself from the matter, my matters and my partners' matters and their property would have been stolen already by John Graham. And it's way past being stolen, by the way. You can't steal no property from me, none of you. Because the law is the law and the rule is the rule and the Constitution is the Constitution. And guess what? Anthony Thought know all of them and willing to stand up and fight for my stuff. Nobody not going to thief from me in an open sight or the law and the court. I am a citizen of this country. I respect the Constitution. I live by it. And the law states if I live by the Constitution, then that Constitution is going to protect me. And the protection I get from the Constitution is through the JCF, who are there to protect and serve. So you might as well give it up. And I've said, those of you who have engaged in this fraud, whether directly or claiming indirectly, whether you think you're sitting in the office behind the scenes and hiding documents or making documents disappear, you form part of the conspiracy. In a previous tape or in documents, I stated at least 10 attorneys, both local and international, are involved in this conspiracy, plus Capital One. And how many of you behind the scenes in the courthouse gave service to these people? It means that you're part of the conspiracy as well. And you never even had to meet everybody in the conspiracy. So I think you should go and research what is a conspiracy and look up chain conspiracy. Conspiracy, which means involve a whole bunch of people trying to defraud somebody else by fooling a third party. And then you think you can get away with just being there. I've offered a reward to say, if you know these people who've done this, and I didn't restrict it to my matter, I said, if you know and you can turn in judges and attorneys who are engaged, and officers of the court are engaged in fraud in the court, then become a whistleblower, and we will pay you that $1 million with conditions. And I will be putting up that $5 million for the reform of the judicial process. It's tied into our projects, yes, but I'll go further. Once we collect our damages, which we will collect, I'm also extending the option that we can pay for that out of that as well. So, in short, just a brief list of documentation that I think I want to say to the JCF and law enforcement generally, that don't fall for the tricks that the cases have been running from 210 and therefore the statute of limitation has expired. There are 3 topics I want to mention. The statute of limitations. The statute of limitations on all the matters pertaining to the initial claim is still in effect. Why is it still in effect? Even though the claim was dismissed in 2015, May 29 or May 2015, it's still in effect. Why? Because we're still going to court on our damages and we're still waiting on the final order. And until we get the final order on a particular matter, the statute doesn't start running until that point. So these people are playing the games in trying to drag this thing out and trying to run the clock on the matters, thinking, well, by the time it comes to a certain date, they're going to say, well, the statute has run. No, it's not run, because it's still actively in front of the court. On case number 2010 HCV 02692, Capital One NA versus Business Ventures Solutions, myself, et al., that matter is still in front of the court, and all the evidence is there for the JCF to prosecute these people, especially when they stole our property out of that matter. And they did steal our property because they appeared in court in the matter of which is the latest matter filed in 2021, claiming they own our property, which is fraud. And again, it's an affidavit where they have admitted stealing the property, where they have admitted. So affidavit evidence with them making those statements is there in court. So again, you don't even have to interview these people. Their affidavit evidence is there. Alexis Robinson, John Graham, and about 4 others, Steve Rapier, Lauren Gallagher. No, I don't think Lauren Gallagher ever gave an affidavit, but if she did, it's there. But the VP of Capital One, the Vice President of Capital One, gave an undertaking that's binding. I don't think he gave any of the affidavit backing up the lies. No, he didn't. About taking or owning our company, and that we asked them to represent us. I don't think he did, but we do have affidavit evidence. And the point I'm making to law enforcement is that you don't even have to have to interview these people. They gave affidavits, evidence, and the documents are there. All you have to do, go down to the courthouse and collect them. And I'm pretty sure you can get them without paying for them under the circumstances, because the court has implemented orders where you have to pay $100 per copy, which is more expensive than even commercial enterprises. And why is it so expensive for documents to be copied at the court, especially when poor people use that court or need to use a court? You're adding to the cost of the people. All right, so again, I think that should be revisited to ensure that justice is done and people have access to the courts, because every move that's designed to limit people's access to the court is in violation of the Constitution. It's like those laws that they passed in the US when they had Jim Crow era after so-called segregation ended. They came up with all kind of things like people have to pay for they have to do tests before they have to can read or write before they can vote. Anything that's put in the place of a person exercising their constitutional right is in violation of the Constitution. So in our case, you could go down to the courthouse as law enforcement. I don't know why, or I don't see any reason why you couldn't, and get authenticated evidence by way of the affidavits that's in court. And as I said, one of the things I want to point out is that remind law enforcement that on October 26, 2017, one of the orders that's very important in dealing with this matter is an order made by Mrs. Justice McDonald. And why is that order important? Because it sets the stage for this matter coming in front of Justice G. Brown. So there's a flow chart of evidence verifying what we said, that we were appointed by the court to represent business ventures and solutions. And in addition to that, Justice G. Brown had also made orders that the actions and the court orders from the US stating that they own business ventures, which we proved couldn't have happened because it was actually sold before that order was made and the so-called acquisition completed. It went in front of Justice G. Brown on 16 May 2018, where he said no order from a US court, especially an order that deals with property and property rights, could be enforced in Jamaica. He also ruled that and appointed me the representative, and he said I was to proceed in representing business ventures in these proceedings. Why is that important? Because Alexis Robinson showed up, and judges including Kirk Anderson, Justice B. Morris, allowed her to come in and represent business ventures and solutions because they claimed she was representing the owners, and the owners had appointed her or retained her and her firm to represent business ventures and solutions, which were all fraudulent representations. And when I'm pointing to the orders of the October 26, 2017 formal order made by Justice McDonald is because it sets out the fact that upon the case management conference coming on for hearing this day, and after hearing Mr. John Graham, Miss Stephanie Graham, and instructed by John Graham and Company, attorney at law for the claimant, and the claimant in this case was capital 1 NA, and the second defendant, Mr. Anthony Thorpe, present. It is hereby ordered that the case management conference is adjourned to the 16th May 2018 for the court to determine two preliminary issues. A, whether Mr. Thorpe can properly pursue or defend any claim in a representative capacity or otherwise. And B, whether the inquiry for the damages should be heard in two separate hearings so as to determine the issues raised in paragraph 7 of the Honorable Mr. Justice Batt's order of the 27th January 2017. Now, the orders of Justice Batt, January 2017, was when Justice Batt abandoned the matter that was set for assessment of damages based on an application by Mr. John Graham about whether we are entitled to damages or not, which is what that was about. And as I said, this sets the matter for the matter coming in front of Justice G. Brown. Just wanted to see the judge's name and the orders that were given, those two. The others are irrelevant right now. It's just saying to prepare the document. All right, so that order sets that. Now in, and I'm gonna find that. Here it is, and I'm showing you the handwritten notes of the judge. This is Justice G. Brown's orders, and I'm going to show it to you and read it so you could understand why this alone is enough. Because you don't need to have anything but more than one count of fraud. I've listed a whole ton of it from yesterday that took place. But now, with Alexis Robinson and John Graham and all of them people, Capital One, committing fraud, this ruling by Justice G. Brown proves the magnitude of the fraud, because they disregarded every ruling of the court from the 2710 claim, which came up to 2013, where Justice Morrison appointed somebody to Capital One to become administrator for a dead company, a company that didn't exist. an estate that didn't exist. An administrator for a company or an estate in New York, a trust in New York, which he has no jurisdiction, which is fraud. That's fraud as well. And then, after all of that, and Mrs. Justice Beswick ruled that they have no right or interest, and that we were the successful party, and they should leave us alone. And if they're to take any other action, anybody, in fact, she pointed to us too, any other action that was to be taken in the matter has to file an appeal. But John Graham, no, he couldn't file an appeal. So what he did, in contempt of Justice Beswick's orders, he went and filed another claim, a 2016 claim, essentially asking the court to rule on these very same matters that were dismissed. That is not only res judicata and an illegality in the courts, but there are rulings against it. And I'll point out again to you where the rules of the court state clearly that the ruling of the appeals court must be enforced. So it's a double-edged for them to overcome this fraud, because Justice Beswick, in making her 2015 ruling, also stated that the appeals court had made a rule on this anyway. She had ruled, the appeals court already ruled on it. That's what basically she was saying. And she said the only thing they could do is file an appeal. They acted in contempt of the court. And again, the judgment of the Court of Appeal shall be enforced by the court below. All right. And here are the orders for Justice G. Brown, which should have ended any fraud in the future, but instead of ending it, the minute he made those orders, John Graham tried to come back into court and say those orders or the questions or the issues weren't dealt with. And Mrs. Justice Mackenzie Henry stated clear to Mr. Graham, that's not what the rules are saying. In July 4, 2018, the judge made the orders and set the matters for assessment of damages. And here's what. And again, I'll point out to you that Alexis Robinson showed up in between the date when Justice G. Brown set the matter for damages, claiming the owners, which would have been us, but she's now saying owners, the other Capital One and the parties Capital One claim they represent, and the parties that they represent own the company, and they're there to represent it. So that's a capital offense. It's proving that they stole the company. They already completed the fraud of taking over a company. And what happened there was Justice Kirk Anderson allowed it. Justice B. Morrison allowed it, even though we presented evidence that that was not the case, and we presented the ruling from Justice G. Brown, right? And this is what Justice G. Brown stated in the document I just showed, his handwritten document. assessment of damages is set for 2 days on the 29th and 30th of January 2019, commencing at 10 a.m. Case management conference adjourned to 4th July 2018 at 2 p.m. Now that case management conference was adjourned to July 4th, 2018 for the purpose of orders we had applied for interim payments and remedies. Because when you are damaged extensively, the court rules allows the receiving parties, the damaged parties, the judgment creditors to apply for interim payments because the damages were substantial. So it was set for the 4th, and that's when John Graham came up again in contempt of the orders of Justice G. Brown and in contempt of all the orders that went before, and said, oh, that's not what happened. And Justice Henry Mackenzie put him in his place. 3. They are to file judges' bundles 4 days before the CMC. That's the same CMC. 4. Mr. Anthony Tharpe is permitted to represent the defendant's company in this proceeding. Who are the defendants? Anthony Tharpe, Business Ventures and Solutions, Inc. Well, at this point, John Graham had dropped the claim against me. So no, it was Business Ventures and Solutions, Inc. that was the defendant. So here Justice G. Brown is stating, and I say in his handwriting, Anthony Tharpe is permitted to represent the defendant company in this proceedings. Claimant attorney to prepare and file the notice. So he also gave orders for them, Capital One, John Graham, to prepare and file the notice. So they can't say they forgot, they didn't know. But what this is saying, Justice G. Brown listed items ahead of this number 4, and he said, assessment of damages. He said the CMC for the 24th of July 2018. And then he went on, Anthony Tharpe is permitted to represent the defendant in these matters, or this matter. Is that any clearer? So again, we are not here telling or making up any stories. We presented all these facts, and I'm saying to law enforcement, you don't have to dig or come up with any analysis. The court orders are there, and they're certified, signed, and authenticated. In short, they have been perfected. And we need to see action. And I'll just point to this document here, and you see, I'm going to mostly show you the seal and everything. This is a document that was filed with the state of New York and the Florida Department department of cooperation, division of corporations in both areas. And what it states is that after Alexis Robinson, John Graham, and all of them came with this nonsense about them owning the company, and they took measures to take over the company, this document was filed with the state of New York and Florida. And Florida proceeded to correct the stolen company document where they removed us, or removed me from the company, and corrected it and advised us to file with local law enforcement. We left the one in New York alone because we were concerned that if we removed all of them, they could say, well, the statute of limitation on the fraud expired, so law enforcement couldn't use that against them. Well, it's still in effect, law enforcement, and the Jamaica government arm, the security arm, has the power to now use that to investigate and convict these people, because the statute of limitation is still in effect. And what it says here, to the Division of Corporations of Florida, State of Florida and New York State, Business Ventures and Solutions, Inc. The official, it says, status, administratively dissolved and therefore inactive. Because we had administratively dissolved the company and made it inactive. It says the official records of the Division of Corporation of both the state of Florida and the state of New York will clearly show that I am on record as the only Chief Executive Director Officer of Business Ventures and Solutions Inc. from its formation date of incorporation in the state of New York and registered in the state of Florida as a foreign corporation to date. This affidavit serves to notify all parties and public bodies, both local, state, and federal agencies and branches of government, that I nor any other director of the said corporate entity, nor administratively dissolved in both states mentioned above, have not, did not, have never come to or voted on any resolution to amend the official records of the corporation as it now reflected in the official records of the Division of Corporation of the State of Florida. Any such change, including the change of registered agent from me, Anthony Tharp, to Corporate Services Company of 1200 Hayes Street, Tallahassee, Florida, was fraudulently made on the instructions of Capital One. The fraudulent changes have been used to defraud successors in the interest of the administratively dissolved corporation. I therefore notify the Division of Corporation in both states and any other state where such change have been filed by Capital One directly or through its agents that the official records of the corporation was not and has not been changed from its original filing date to date, and all subsequent changes must be corrected and the records returned to their original filing by Anthony Tharp when first filed. The fees required for further amending the records to their original filing date has been included in the correspondence to the Florida Division of Corporation. And again, it's notarized and certified. So, reading this to you because, again, wanted you to be aware that the evidence is there, and so we want to make sure that everybody understands that the crime that's been committed has been authenticated. All the evidence is there for the prosecution, and so we wrote to both the states, and we'll, as I explained to you before, we take measures that were relevant to us. Now, I said to you yesterday that because I didn't want them to play the game of this nonsense about them purchasing my 100% interest in Business Ventures as a ploy, or an excuse to steal a property, I refused to. I had one of my partners go back on record and act as the registered agent. I think I read it before, but just reminding you, I think we did it. June 26, 2019. Yeah, we read it yesterday. So that was Mr. William Ridgely. But just showing you again. This is Mr. William Ridgely, who we put in place of me on the records to the Florida Division of Corporations, and they acknowledged and provided a certificate, which is on the records of the courthouse, to show that we dealt with the fraud. Now, as I said, the fact that they completed the action and did it means they committed fraud, and that fraud is prosecutable, and the evidence is there in the courts. So the police and integrity commission don't need to go interview anybody. Now here is another document now that proves that after we corrected the document in Florida and left the New York thing alone, here is Capital One going in and filing a withdrawal notice on the corporation. Again, a fraudulent act. And that withdrawal notice meant now Business Ventures and Solutions Inc. of New York was no longer in existence. It's not dormant, it's not administratively dissolved, it just not exists anymore because they withdrew it. It's a foreign corporation. And this is what they did. Then they went into New York, which we stated again, and claimed now the New York company that we left in place is now the party that's filing documents in the Jamaica courts that they own Business Ventures. And we already explained to you that because the U.S. is a republic of independent states, that whatever corporate business was done in Florida stays in Florida. So the property was bought by Business Ventures and Solutions in Florida. They sued us, Business Ventures and Solutions Inc. in Florida. So the damages belong to the parties they sued in the Florida corporation. So when Alexis Robinson came back in court now in 2021, 2022, under Steve Rapier, another employee of Capital One, stating now they're a New York State corporation and they own property and all of that. That is a significant fraud. That is fraud, undisputed. And Alexis Robinson produced an affidavit backing it up. And we have the affidavit where Alexis Robinson stated that she was representing the company. In fact, let me look if I see it here. She was representing the company and she was retained by me, or the owners. Here it is. See? That's an affidavit by Alexis Robinson filed in the court. So here she's in court committing a crime, filing fraudulent documents, and she's part of the conspiracy. And it says, I, Alexis L. Robinson, being duly sworn, make oath and say as follows, that my address for the purposes of this affidavit is in care of 21 East Street in the city and parish of Kingston, and I am an attorney at law and a partner within the firm of Miles Fletcher and Gordon, the second defendant. I had sued them, as I told you. So here it is. She's saying she's not only an attorney, she's an attorney in Miles Fletcher and Gordon. So which means Miles Fletcher and Gordon are co-conspirators in the whole matter. And she goes on that the claimant alleges that the first claimant, that's me, the first claimant is the legitimate court-appointed representative for Business Ventures and Solutions Inc., a company with registered addresses in Florida, United States of America, and that it remains a director of BVNS with the authority to represent Business Ventures and Solutions' legal interests. It is also alleged that the defendants have collectively conspired with each other to deprive the first claimant and other beneficiaries and creditors of their interest in BVNS, as well as property situated at Queens Drive in Montego Bay. So here it is, again, on document saying the address for Business Ventures and Solutions Inc. that was sued is in Florida. And if you check later documents, the one I showed you before, you saw where they put up a thing about Melvin Avenue or 735 Causeway Boulevard in Melvin, LA. Then they use an address in Tallahassee as well. Then they use an address in New York as the address of Business Ventures and Solutions. But as I said to you before, two different franchises. Then the vendor under the agreement, I don't need to go through that. That's them trying to relitigate the whole matter, claiming they have some standing to do that. I'm trying to find something else here. Okay, here is Alexis Robinson admitting to the world, because it's in the court's records, that they're committing fraud, or they committed fraud. See? Those are my notes all over. Right? So again, the police don't need to waste time doing any interviews. Just lock them up. My firm was engaged in late 2018 to represent the defendant, Business Ventures and Solutions, in claim number 2010 HCV 02692, Capital One NA versus Business Ventures and Solutions Inc., and to file a notice of change of attorneys. We did so on December 10, 2018 on behalf of Business Ventures and Solutions Inc. A copy of the notice of change of attorneys exhibited hereto and marked as AR7 for identification. This action was taken with the authority and on the instructions of the defendant through its sole director, Steve Rapier, and through Hancock Whitney Bank, the trustee of the Alexander Burnham Trust, the sole shareholder of BVNS, under the signature of its, and they put Lorraine Gallagher. A copy of the certificate of identity for Lorraine Gallagher is engagement of me and my firm is exhibited hereto and marked as Exhibit AR8 for identification. Now here are some very interesting facts. One, we already pointed out that when the matter came in front of Justice Mason regarding the this whole thing, and Alexis Robinson representing Business Ventures, but Alexis Robinson stated when appointed to the Justice Mason that Justice G. Brown had already ruled that I am the legal representative. Well, she says it's a different matter. So here's a different matter, but here's Alexis Robinson admitting in her affidavit that she's representing Business Ventures and Solutions, Inc. from the 2010 claim. The very matter she says she wasn't involved in, and reminding you that a claim has been dismissed. So we're in front of the court not for any issues with claim. We're just there to collect our money. So technically, Alexis Robinson don't have anything for our capital, has nothing at all to do with our money. That's our property. And all we're there to do is for the court to give you a formal final order to say the amount that was proven is correct. That's it. So I hope you're seeing the picture. So a number of things are here. They're fraudulently represented to the court that they're representing Business Ventures, appointed by the owner or director of Business Ventures, when Justice G. Brown appointed me and told them that the order that she claimed she was operating on from a foreign entity, Capital One, could not be enforced in Jamaica in its 2016-2018 ruling. May 16, 2018 ruling. So she's committing fraud there because she's lying. All right. Then she goes on to say Lorraine Gallagher is the trustee, or the signature for the trustee, which is Pratt Whitney Bank. Those institutions are all connected to Capital One. So Capital One is here again trying to fool the court by simply changing the name on the institution. Capital One is just trying to insulate itself because we filed documents with the U.S. attorneys and with FBI and Controller of Currency. And when the FDCPA wrote to them to say, what's going on here? You're not supposed to be doing this. Capital One said, oh, it's not we. I didn't do it. Like that song. Shaggy, I think, Shaggy song. It's not me. It wasn't me. It wasn't me. It was this institution, Hancock Whitney Bank. Why? Because they own those entities, or they're connected, and because now it's another corporation, they did a quick flip or sale or assignment of that account to Pratt Whitney Bank, and now claim, oh, it wasn't me, figuring they're protected. But that whole scenario is fraudulent as well, because they're agents for Capital One. And what she said in the document is that Pratt Whitney is not the trustee. It says Pratt Whitney in another portion of the thing here. Said Pratt Whitney purchased the operations, the business of Capital One, as the trust, and that's not how it works. You purchase a business, you don't purchase a trust. All right. So even if you're managing it, you're not the owner of the trust. Capital One is. And they stated in further later documents as well. But in order to try and cover the tracks here. But I'm just showing all that I'm saying here, everything that's that's docketed and documented here is in fact fraud. And she confirmed it in her affidavit, which means there are several counts of fraud on her behalf, her part. And then Lorraine Gallagher, I'll remind you, as I said to you before, Capital One, they develop a process and a system where when one case is dismissed or they can't win the case, they file another case using its employees. They filed 3 matters so far. One, the 2010 claim, where Capital One claimed it was the claimant, but represented by Lorraine Gallagher and John Graham. Then when that failed and the matter was thrown out, they filed a 2016 claim in the name of Lorraine Gallagher, an employee. When they know this wasn't going to work out and they withdrew it from the docket and withdrew all the claim, then they proceeded shortly after that to file another claim with Steve Rapier, the employee of Capital One. You see the process. All of that is fraud. All those actions are fraudulent. So, as I said, we have the evidence. It's there. And one of the things we provided in our documents, and we're providing it to the police, if you want to look at what Capital One did in terms of stealing the company, my company, you could refer to the Magnitsky Human Rights Violation Act. It came out of a move by Russian mafia. That's what these people are engaged in. They're copying the moves of the mafia. And they stole a company of a billionaire and then took it over just like they did with Business Ventures in New York and robbed it of hundreds of millions of dollars and then killed the poor guy. Alright? Because they put him in jail because he was fighting it. The same thing that's happening to us. And so it's well documented. The US passed a law dealing with it, and several countries around the world have also made laws that the UN pursues people on this or exposes fraud and corruption on this. And it's spelled Magnitsky. Alright, so that's the act they must look up, and then they'll find how Capital One and John Graham and all of them got involved in fraudulently stealing persons' company. And here's just a brief. In that act, the Magnitsky case, the thieves used forged contracts to claim Hermitage, which was Magnitsky's company, owed them $1 billion to a shell company. In our case, Capital One claimed, using our documents, to say in a fraudulent claim in Florida, the bankruptcy court said I owe them $600,000. So you see the relationship, the commonality. In the bankruptcy court, they filed a petition and said I owe them. What they did then is take over the company and, as I said, kill the poor guy. It's well documented, so you could look into it. So that said, law enforcement has no excuse whatsoever. We've presented evidence and made the case that these people have been committing fraud. And what I present is just the tip of the iceberg. And there are so many instances of fraud and corruption that it's unbelievable. And we don't want to have anybody coming up with any excuses because it's in court. I've already pointed out to even the crafty Justice Sykes say you don't need any order from the court. Now here's what they did. If you notice, this is a report from Guardsman. This never happens, or it doesn't happen. I'm in court, they have all the information on me. What do you think they did? They went and had Guardsman carry out an investigation about me. Then they went about publishing this in the public record. So all of this is public information on me. Have you ever heard of anybody going through the trouble of investigating any litigant? That's not even that the court ruled in our favor. Then going and file a claim, put the information about me, where I live, all of that kind of thing in there. What do you think they're doing? They're setting up something, right? As I said, they killed Magnitsky. That's the same thing they did. They forged documents. They took documents and the information they knew about me because of the court proceedings. Then they went and they took over the company. They filed in New York that they owned my company. Then they came back to Jamaica. Oh, they owned my company. Then they went and did a public search on my person, published it, so everybody knows where I am, and then take over the company, come into court that they own the company, despite rulings of the court. All of that fraudulent. And the circumstantial evidence is there, as I've been warned to be very careful. Why are these people using a legitimate, and that's the game now, they use a legitimate security company. So I'm not saying anything is wrong with guardsmen. They're hired guardsmen, do a search on me to find out my locations, where I am, publish it in the public records. So when anything happens to me, they can say, well, they don't know nothing about it. But guardsmen they publish a report about me. Why? Have you ever heard of anything like that? A litigant who lost the battle will publish somebody's information in the public realm, and then when somebody shows up on my door or some back door or behind me on some bike, you're going to hear they don't know nothing about it. So this is circumstantial evidence to law enforcement. Say, lock the bastards up. The same thing they did to Meniski. That Russian, look up the thing, is what they plan on doing. But the stupid asses think I'm alone. Right? Say the names. Say the names. Say the names. 1, 2, 3, 4. 4 pages full of names. These are the owners. These are the people you're trying to rob. So you take me out, you're going to kill all them people too? It's law enforcement and the Jamaican Constabulary Force or the Integrity Commission or the Jamaica government or the Supreme Court and these justices. Are you behind this scheme to defraud and hurt people? I don't know how much they're paying you, what they're paying you, if they're paying you. As I say, if it's curry favor, I don't know. For the Jamaican public and people. That's what these criminals have been doing. That's the kind of thing these small mind people, these rat brain people, are putting this country through and putting people's lives through. This project should have been completed from 2013. And so we're still here, being denied our right. So please subscribe, share the video. Yeah, it's long, but as I explained to you, if you need to really know what's going on, you're going to need the facts. And I'm not here to create hysteria. I'm here to educate you and educate you so that you could make your voice be heard, because these people aren't robbing me, they're robbing you. This is your country they're hurting. And do you want your country in that shamble of a state? Here we have a 3-tower, 125-story high-rise skyscraper. We would have the highest building south of probably Chicago or out of Canada, because no building is at 125-story anywhere in North America as far as I know right now. So we'd be threading on the route Dubai and all them places took, and you see where their industry is going in terms of tourism, just because of architecture and development. We could have had and be way ahead of the game by now. As I said, we have so much proprietary business linked to these development that it would take Jamaica to a higher plane of existence as it comes to economic growth. But these people in court with corrupt attorneys and a mass media, a media that we have gone to protect, have attorneys there telling them not to publish these facts and evidence for the Jamaican people to hear. That's what we have, and you have to speak up. We're going to do another video, and we're going to do it on this media thing and this excuse about using attorneys to tell them don't publish evidence, or don't publish the truth, don't publish stuff that they can't be sued on, because all of this is public record. So how you going to come and tell newspaper and radio stations not to publish or broadcast stuff that's already public information, already published? It's published online, it's published on YouTube, it's published on Amazon. So how you going to tell them don't publish it? Well, you're trying to cover up your own lawyer buddies who are involved in theft and crimes, and you don't know better. Hold on, no attorney will engage in that kind of cover up, just as bad as the criminals, because you don't do it because you probably are engaged in it. And you need to check on yourself and correct, because this country cannot stand the foolishness and the criminality that you're not getting away with. And I, for one, and them whole heap of people you see on this page, they're committed to stop you. Thank you. Have a good one. Subscribe, share, form communities, scream out for fixing this. It can be done. Thank you.